Have you ever sat down, really sat down, and thought about what happens to your family the second you die? Not in a vague, I should get life insurance kind of way, but concretely, specifically. What happens to the real estate portfolio you spent 30 years building? The savings account you scrimped on? The family business? If you're like most people, you've done the responsible thing. You went to a lawyer, you signed a few papers, and you walked out with a will. You probably felt a massive sense of relief. You thought, okay, I've done the hard part. My family is taken care of. If I get hit by a bus tomorrow, they're protected. I'm here to tell you something that might keep you up at night. That feeling of security is a lie. In fact, relying on a will might be the single most dangerous financial decision you've made for your heirs. It is not a shield. It is a permission slip for the government to seize control of your assets, freeze your bank accounts, and drag your family through a public, expensive, and humiliating legal process called probate. Today, we are pulling back the curtain on the biggest gotcha in the American legal system. We are talking about why a will is often nothing more than a very expensive piece of stationery, and why, if you actually want to protect your legacy, you need to stop looking at wills and start looking at trusts. I am the Wealth Guardian. This is the channel that bridges the gap between complex legal jargon and practical, real-world asset protection. If you want to keep what you've built, hit that subscribe button. Because what I'm about to show you is the difference between leaving a legacy and leaving a mess. Before we go any further, an important reminder. Everything in this video is strictly for educational purposes. Nothing here constitutes legal or financial advice tailored to your personal situation. Laws vary wildly by state and country. Always consult a qualified estate planning attorney or solicitor for guidance specific to your circumstances. What this content is designed to do is help you understand the landscape of the risks, so that when you do seek help, you know the right questions to ask. Okay, let's get into it. What actually happens when you die with just a will? Let me paint you the picture nobody told you about at the lawyer's office. The second you pass away, legally, almost everything you own in your own name shuts down. Your bank doesn't care that your wife needs to pay the mortgage next week. They see a death certificate, they freeze the account. Your investment account? Frozen. Your house? It can't be sold, refinanced, or transferred. Your LLC? Locked. Even though you have a will that says leave everything to my wife, your wife has zero legal authority to do anything. She has to go to court. She files your will with the county probate court. The court then has to validate the will, which means they notify every single heir at law, even the people you intentionally disinherited, and give them a chance to contest it. The judge appoints an executor. Even if you named one, the judge still has to approve them. And then the clock starts. And it does not stop for a long, long time. This is probate, and it has 4 brutal consequences. Number 1, time. The average probate in the U.S. takes between 12 and 18 months. In states like California, New York, or Florida, it's not uncommon for it to take 2 to 3 years. For that entire time, your family's assets are in limbo. I had a client whose dad died with a perfectly valid will. His mom couldn't sell their vacation home for 22 months to pay medical bills, even though the will said it was hers. The court controlled the timeline, not her. Number 2, cost. And this is where people get angry. Probate isn't free. It's brutally expensive. The court takes fees. The executor is entitled to a percentage. And in most states, the probate attorney is paid a fee based on the gross value of your estate, not what's left over. Let me give you the California example because it's public. On a $1 million house that has an $800,000 mortgage on it, the statutory attorney fee is $23,000. The executor gets another $23,000. That's $46,000, plus court costs, plus appraisals, plus filing fees, to pass on $200,000 of equity. Your family pays the fees on the million, not the 200 grand. Nationally, expect 3% to 7% of your entire estate to evaporate into probate costs. You paid for a will to save money. It just cost your kids a new college fund. Number 3, it's completely public. A will becomes public record the second it's filed. Anyone, and I mean anyone, can go to the courthouse website, type in your name, and pull up your entire inventory. What you owned, what it was worth, who you owed money to, your kids' names, their addresses, and exactly what they inherited. This is why you get those predatory letters in the mail after someone dies. It's why long-lost relatives and creditors crawl out of the woodwork. You've just published your family's financial blueprint for the world to see. Number 4, you lose all control. A judge who has never met you is now in charge of your family business. If your kids are minors, the judge decides who manages their money until they're 18. And at 18, they get a full lump sum check, no matter how responsible they are. If someone contests the will, your family is now in a public lawsuit against each other, paying lawyers with your money to fight over your stuff. And here's the part that stings the most. A will guarantees probate. It doesn't avoid it. Think of a will as a set of instructions you wrote for the probate judge. It's basically you saying, "Dear Judge, here's what I want you to do with my stuff after you take control of it." The will is powerless until the judge says so. So if a will is just a ticket straight to probate court, what's the alternative? Part 2. The tool the wealthy have used for 100 years. It's called a revocable living trust. And no, it's not just for the Rockefellers. I need you to think about it differently. Forget the legal jargon. Think of a trust as a private bucket. While you're alive, you create this bucket, and you put almost everything you own, your house, your bank accounts, your rental properties, your business, into the bucket. But because it's a revocable living trust, you still own the bucket 100%. You're the trustee. You can buy, sell, refinance, take money out, put money in, change your mind just like you do now. Nothing changes for you day to day. The magic happens when you die or if you become incapacitated. Because the assets are already in the bucket, you don't own them in your own name anymore. The trust does. So there is nothing to freeze. There is nothing for a probate court to control. Instead, the person you privately chose ahead of time, your successor trustee, usually your spouse or adult child, simply steps in. Immediately. No court, no judge, no permission slip needed. They follow the instructions you left inside the trust document, and they can start paying bills, managing the business, and distributing assets to your heirs in weeks, not years. Privately, for pennies on the dollar compared to probate. Let me give you the side-by-side. With a will, your family goes public. Your family waits 12 and 24 months. Your family pays 3 to 7%. Your family loses control. With a properly funded trust, your family stays private. Your family acts in weeks. Your family pays a fraction of the cost. And you keep control, even from the grave. And you get 2 huge bonuses a will can never give you. First is incapacity planning. A will does absolutely nothing if you have a stroke, get dementia, or are in a coma. A will only speaks when you're dead. A trust speaks the second you can't. Your successor trustee takes over your finances seamlessly, avoiding a living probate called a conservatorship or guardianship, which is even uglier than death probate. Second is control for your kids. With a trust, you don't have to leave your 21-year-old $500,000 in cash. You can say, give them 1/3 at 25, 1/3 at 30, and the rest at 35. You can protect that inheritance from their future divorce, from a lawsuit, or from bad spending habits. A will can't do that effectively. Part 3. But I heard trusts are expensive and complicated. This is the biggest myth in estate planning, and it keeps middle-class families stuck in probate. Yes, a trust costs more up front. A simple will-based plan might be $500 to $1,500. A comprehensive revocable living trust plan done right by a real attorney is usually between $2,500 and $5,000, depending on your state. But you are not buying paper. You are buying insurance. You are choosing to pay $3,000 now so your family doesn't have to pay $40,000 to $70,000 later in probate fees on that same house. It's like saying, seatbelts are expensive while ignoring the cost of the hospital bill. The other mistake I see constantly? People get a trust and then never fund it. They put the beautiful binder on a shelf but never deed the house into the trust, never change the bank account titles. An unfunded trust is worthless. It's like buying a safe and leaving it empty. Funding is the work, and a good attorney will walk you through it. So who needs a trust? It's simpler than you think. If you own a home, if you have more than $50,000, $100,000 in total assets, which is the small estate threshold in most states, if you own a business, if you have kids under 30, if you value your privacy, you need to at least have the conversation about a trust. A will is fine if you are 25, single, renting with no kids. For everyone else who has actually built something, a will alone is dangerously incomplete. So what do you do next? Step 1. Do an inventory. List your home, bank accounts, life insurance, retirement, business interests. Step 2. Don't go to an online will mill. Find an actual estate planning attorney in your state whose practice is focused on trusts. Step 3. Ask them this exact question. How will this plan keep my family out of probate, and how will it work if I become incapacitated? If they can't answer that clearly, walk out. Step 4. Commit to funding it. Look, I know this is uncomfortable to think about, but planning isn't for you. It's for the people you love who will be grieving while cleaning up your mess. A will leaves them a map to the courthouse. A trust leaves them the keys. The goal isn't to cheat the system. The goal is to make sure the people you love aren't punished financially and emotionally at the worst possible time of their lives. If you found this information valuable, do me a favor and drop a trust in the comments so I know to make more content like this. Smash that like button, subscribe, and hit the notification bell so you'll be alerted when I drop the next one. I'll see you in the next video.